Hello, good afternoon. Thank you all for being here. Today is Tuesday, November the 17th, and this is a live webinar on strategies that can save estate taxes. My name is Ashley, and I'm here with our presenter, Vincent, whom I will be introducing momentarily. But first, let's move into some housekeeping. We've allotted roughly 45 minutes for the presentation and Q&A. All of your lines are muted, but you may type your questions into the questions box provided on the Zoom toolbar. If you're on Facebook, you can use the comments section. We will be monitoring it throughout the program. When sending your questions, please remember to include your email address. We will do our best to answer every question, but if we run out of time, we will follow up after the program. We are sharing the PowerPoint. Please write in the chat box and let me know if you can't see or hear something. This webinar is being recorded. We will share the recording along with the PowerPoint via email by the end of this week. It will also be available to stream on our website. And finally, please complete the survey that will appear in the web browser when you leave the webinar. So let's get to know your speaker and managing partner, Vincent J. Russo. He has earned his Master's of Law in Taxation and is a certified elder law attorney. He's a member of the Council of Advanced Practitioners, founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys, and co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs. He's author of the seminal treatise, New York Elder Law and Special Needs Practice for Lawyers Practicing in New York, and he enjoys listening to the Beatles in his spare time. That just about wraps it up. I should mention quickly that this is part 5 of our estate tax series. To recap, we've done one presentation a month on this topic. I believe that started back in July. Part 1 was the nuts and bolts of estate tax planning. Part 2 was the New York State estate tax planning. Then part 3 was over federal estate tax planning. And last month's presentation was estate tax planning for married couples. Hopefully you all got all that. If you missed anything in this series or would like a refresher, send me a message in the chat box and I will send you a link to stream the recordings on our website. All right, I believe we're going to turn our webcams off now to focus on the slides. And Vincent, the floor is all yours.
Okay, thank you, Ashley. And I was going to quiz you on the 4 parts, but you jumped ahead of me on that one. It started out as like a 1 or 2 part series, and then it just kept growing as I realized there was more and more to discuss with all of you about estate taxes, with the goal really of understanding the impact of estate taxes on your estate. Everybody works so hard to have what they have, and everyone wants to protect their assets and wants to pass on the maximum amount. So the impact of estate taxes can greatly reduce the size of your estate, depending on how significant of an estate you have. So we will address today strategies that are available to save estate taxes and how to create an estate plan that protects you and your family and your assets. So with that, we will start with just a little bit of background, which we've covered in the prior presentations. The steps to saving estate taxes. First step, you have to understand the size of your estate. You have to list all your assets and be honest about the value of those assets. Don't underestimate them, and make sure you're counting everything, including retirement accounts, life insurance, bonds, stocks, cash, real property, all your assets. You do get to also, it's a negative, subtract liabilities when calculating the size of your estate for estate tax purposes. Then once you know the size of your estate, you need to think about what the consequences are based on the fact that you're entitled to a federal, and if you're in New York, a New York State estate tax exemption. So a certain amount of assets you can have without a tax, and the tax is typically applied on the amount in excess of the exemption amount. You also want to understand the concept of step up in basis. That's really a positive, that when assets are in your estate and you pass away, the basis of those assets steps up to the fair market value at the time of your demise. So if your family then sells those assets, they avoid capital gain taxes. We've also covered in prior presentation New York State estate taxes and talked about the cliff. And the cliff can be really devastating in terms of the amount of tax that can be charged by New York State if your New York State estate exceeds a certain amount. So go back on that in our prior presentations if that's a concern of yours. We'll touch on it a little later as well. And then gift strategies and the use of trusts. That's where we're really going to focus today in talking about the planning tools that are available to save estate taxes and asset allocation, that once you're in the process of putting in a plan to save estate taxes, how you own those assets, especially if you're married, whether it's in your name, your spouse's name, or jointly, whether you've named a beneficiary, all impacts the flow of those assets upon your demise and potentially how they'll be taxed. So what is a taxable estate in 2020? Well, at the federal level, you'll see that the tax rate is 40% once you have a taxable estate, and the exemption is $11,580,000. So you can have up to that amount without a federal estate tax. New York is not as generous with their exemption. It's $5,850,000, and their top rate is 16%. It's pretty high. And there is a tax cliff. And the tax cliff, basically, under the current law, says that if your estate is in excess of is equal to or greater than $6,142,500, you lose your estate tax exemption. So every dollar is taxed in your New York estate. So that can be really significant in terms of how much tax can be charged. These exemption amounts are adjusted for inflation on an annual basis. We'll be getting new numbers in the next few weeks for 2021. So an example of the estate tax, you'll see here at $5,850,000 or less, there are no estate taxes, federal and or in New York. When you hit that cliff amount, you'll see that the New York tax is $528,240 because New York is taxing every dollar that you have in your estate. So planning can be done to save that $528,240. If you have an estate at $11,580,000, the good news is still no federal tax, but New York would have a tax of $1,319,600. That is a lot of money. That's over 10% of your overall estate. And if you had an estate of $23,160,000, it's just an example, the federal tax would be $3,363,040. New York, $3,172,400 for a $6,535,440 tax. So there is where we will spend our time. Looking at that last column, how do we reduce those numbers or even get those numbers down to zero? So in light of the recent presidential election and discussion that's been had previously about what may be proposed in Congress in the coming year, I wanted to just show you what the tax looks like today under the federal estate tax rules and potentially what it could look like based on certain assumptions. And those assumptions are that if that exemption was reduced from the current amount to 3.5 million, and the tax rate was raised from 40 to 45%. So that's where the discussion has been, or some numbers under negotiation. It may be a greater exemption amount or a lesser tax rate, but this will be up for consideration whether there should be changes in the state tax rates and changes in the exemption amount in the coming year. So if we were to look where we are currently, there's no federal estate tax up to 11,580,000. And the number for the federal estate tax at 23,160,000 is 4,632,000 without taking a deduction for any state estate taxes paid. The potential, if we went to a $3.5 million exemption and a rate of 45%, you could see that at 5,850,000, we're already over $1 million in taxes. At roughly the 11 million mark, we're at closing in on $4 million. And at 23 million, the potential estate tax could be 9 million, close to $9 million, which is close to doubling the current estate tax under the current rules. So this is a concern that I'm hearing from a number of my clients, and they're anxious about this. I think we have to take everything into account here. It's not just a numbers game. What are you comfortable with in terms of any sort of gifting program to reduce taxes? What is the likelihood that Congress would act? We don't know what the composition of the Senate will be at this point. We don't know if the president would present a proposal that was discussed earlier prior to the election, or whether that might change. So there are a lot of questions. The one thing I know, though, is that if you have an estate of in excess of 5,950,000, you need to pay attention. And the reason you need to pay attention is you pushed into New York State estate taxes, you pushed into the federal potential estate tax world. That number would be 5,850,000 based on the New York exemption. So if you have an amount that's less, but it's likely due to asset appreciation or inheritances that your estate will be larger in the future, you also need to pay attention. We also need to be aware that under the current federal law in 2026, that exemption is scheduled to be reduced to 5,900,000. So even if we don't have a tax today, I have an $8 million estate, I could have a taxable estate when I get to 2026. And then lastly, I mentioned the 3.5 million potential reduction in the exemption if Congress was to act and if this was to be proposed. So let's talk about the estate tax planning opportunities here. We can make gifts to individuals or to trusts. I call these dollar for dollar gifts. So an asset worth $1 million, if it was gifted, then the gift would be $1 million, and it would be offset by the exemption that you have. You can use that 11 million plus dollar exemption either by gifts during lifetime or upon your demise by the passing of assets in your estate. Another area is life insurance trusts. So when a client comes in with a taxable estate, one of the first things I'll look at is whether they own life insurance. And if they do, life insurance is income tax-free, but not estate tax-free. So we would want to avoid any taxation on the death benefit of life insurance by placing it into a life insurance trust. If married, we'd want to take advantage of credit, shelter, and marital trusts. and also asset allocation, which we discussed in one of the previous parts of this series. So let's go to a gifting program and the general rules. You can give away $15,000 per person per year. And so that's one avenue to reduce the size of your estate. You can make gifts of greater amounts and offset it by your unified gift and estate tax exemption of $11,580,000. And the good news is that there is no New York State gift tax. So it's just the federal exemption we're concerned about. You can reduce the size of your estate subject to estate tax by making outright gifts or gifts to certain types of trusts. Typically, those trusts are irrevocable trusts. If you have a revocable trust that you've set up and funded, it will be included in your estate subject to estate tax. So what type of assets should we consider gifting? These are assets that generally will have no impact on your lifestyle, your ability to spend money and have access to funds for you to continue the way you want to live. Also, the type of assets I would look at would be assets with little or no appreciation. So an asset that's highly appreciated, if I give it away, I lose the opportunity for a step up in basis upon my demise. Another set of assets that would be good to look at would be assets that will appreciate significantly in the future. I had a discussion with a client this past week where they have stock issued from their company and they're an employee. And if that company goes public, the value of that stock will go up tremendously. I had another example where someone had raw land and they were going to build a shopping center on top of that land. So the asset was going to gain in value significantly. So we gifted the land before the building was constructed. And then assets that you have no intention of selling. You only realize under the current law capital gain when you sell an asset. So if you never intend to sell it, we're not as concerned about the basis. So let me give you an example, a simple example of gifting to save estate taxes. Let's say John has an estate of $11,580,000. I've already told you before that the New York estate tax would be $1,319,600 and no federal estate tax. Well, if John made gifts of $5,730,000, that would reduce his estate to $5,850,000, and then there would be no federal and/or New York State estate tax. That simple plan would have a tax savings of $1,319,600, plus the future appreciation of the gifted amount would grow estate tax free. Now, one might say, well, I'm not comfortable making a gift of that size and giving it to my children and just relying on them to do to manage that asset, those assets appropriately, or to be used for the right reasons. So that's where one might consider making a gift to a trust for the benefit of your children. Now, there's one condition here I have to mention. Even though New York State doesn't have a gift tax law, they do say if you make a gift and then die within 3 years, the gift will come back into your estate for purposes of computing the New York estate tax. So by gifting now and getting 3 years behind you, that asset will be totally out of your estate, realizing this significant tax savings in this pretty straightforward plan. Any amount that was gifted would help reduce that tax to New York State. So if someone's not comfortable making a gift of $5,730,000, maybe they're comfortable with gifting $1 million. All right, so the benefit of significant gifting to save estate taxes. Let's go over another example. Let's say you have an estate in excess of $10 million. and let's, in a hypothetical, say the exemption is reduced to 3.5 million, then any unused gift exemption available today would be lost. So by putting a plan in place today and utilizing the exemption, then we won't have to worry necessarily about what happens next year or in 2026. So if I was to make a gift of that 10 million, I would be utilizing not only the 3.5 if the law changed to that amount, but an additional 6,500, the $6,500,000, and the potential estate tax savings would be in the neighborhood of $3 million. When I did the calculation, 2,925,000 plus future appreciation of the gifts would be estate tax free. Now, this is assuming that there's no federal clawback, and that is our current understanding of the IRS's position. So if we utilize the exemption today, you will not be punished if that exemption amount is reduced to a lesser amount so that the exemption you used today was greater than the lowered amount in the future. All right, I talked about a little about life insurance before, and life insurance is income tax free, but we also should make sure that we have a plan that it's estate tax free. So if I have a life insurance policy, I would want to consider gifting the ownership of the life insurance policy to a third party, or better yet, in a more protective way, to an irrevocable life insurance trust. Now, this is subject to a 3-year clawback rule. So if you have a policy today of $5 million, for example, and you transfer it into an irrevocable life insurance trust, sometimes called an ILIT, and you get past 3 years, then that $5 million policy would be out of your estate. And with a 45% overall tax rate, the savings would be $2,250,000. That's really significant. And so that is a typical strategy that we've implemented over and over again. Now, if you were thinking of buying life insurance, you would set up the trust and have the trust buy the policy, and that would avoid the 3-year rule. 3-year rule only comes into play if it's an existing policy that you transfer into the ILIT. Another strategy is to save estate taxes by discounting. What do I mean by that? Well, what I mean is, can we make an asset worth less for estate tax purposes? Can I make $1 worth 85 cents? And so if it was worth 85 cents, there's going to be less tax involved. Maybe I can get that asset valued at $1 to 65 cents on the dollar. So here's a straightforward example. If you own real estate, you could transfer a small ownership interest in that property and get a 15% reduction in the value of that property. So let's say you had an asset, a home, or a second home worth $1 million. If you added, for example, your children as a 2% owner, you've now created a fractional ownership interest. And the valuation rules come into play that tell us that $1 is not worth $1 if there's a piece of that dollar that's owned by somebody else. So in this example, if we were to get a 15% reduction, we could have an estate tax savings in the area of $67,500. So that seems pretty straightforward, and it wouldn't really adversely impact the owner of that property in any significant way. So that's one strategy to consider. But we'd like to go even further in getting discounts. The larger the discount, the more money we can save for the client. So this is where we talk about leveraged gifts, the power of discounting the value of a gift. in effect, making the asset worth less for gift tax purposes. Hence, using less of your federal estate and gift tax exemption, currently at the $11,580,000, thus saving estate taxes. Also, reducing New York state estate taxes because there's no gift tax law. And we understand that you got to live 3 years because of the New York law back rule. So let's get into some examples here. The kind of strategies you would want to consider if you have a taxable estate. One is to make discounted gifts to trusts. And the type of trust we're going to talk about are GRATs and CUPRITs. Utilizing limited liability companies, LLCs, and making discounted gifts of the ownership's interests in those LLCs. The next strategy is the Spousal Lifetime Access Trust, or a SLAT. This is where you're making a gift to a trust, but you're retaining the ability to access the income and assets for the benefit of a third party. This works really well with married couples, where you could make gifts into SLATs and have access back, if you needed it, of the asset and or the income. Dynasty trusts come into play when you have a significant estate. Why leave assets to your children? Then your estate will be subject to tax, then their estate will be subject to tax, and then assets will be in a watered down fashion passing on to grandchildren. Why not set up a trust that avoids tax in your children's estates, maximizing what can then pass for the benefit of your grandchildren? Also, if you have charitable intentions, charitable gifting can be very valuable, and there are a number of different ways you could make gifts to trusts, charitable trusts, and also benefit from it by tax deductions and or benefit from the actual assets in the trust. So when we get into advanced estate tax strategies, I think about alphabet soup, Campbell's alphabet soup. And so there are a lot of terms we hear about. And so I want to just give you a little more information on each of the terms. You might have heard about GRATs. GRATs are grantor retained annuity trusts. This is where you're putting assets into a trust, retaining the right to receive an income stream for that trust for a number of years. And then after the term, the trust can benefit third parties, your family. The gift into the trust is discounted because of your retained interest. And this can be very powerful. CUPRITs, Qualified Personal Residence Trust. This is where you take your personal residence or a second residence and you put it in a trust and retain the right to live there for a number of years. When that term expires, you could still live there, but you're going to have to pay rent, and the rent can basically be the equivalent of the taxes and expenses for running the household. Here again, a discount would be given to the value of the gift, the residence, into the CUPRIT, because you retained the right to live there for a term of years. And then, as I mentioned, the SLATs, the Spousal Lifetime Access Trust. It basically freezes the value of the gifted assets while allowing access to income and or principal for a spouse. So if I put $5 million into a SLAT, I'll use up $5 million of my gift. That's a dollar for dollar gift. But future appreciation won't be taxed. And if we need to access that income or principal for the spouse, we can still do that. SLATs can be very useful because they're very practical in allowing that flexibility. So we're going to get into some examples. Let's start with GRATs and CUPRITs. So here are two examples of how one could save taxes. Let's say you set up a GRAT and transfer $1 million to the GRAT. That might be your brokerage account assets. Here you retain an income interest at 5%. So you're going to get 5% each year, so $50,000 for 10 years. And let's say you're 65 years old when you set it up. And let's assume that the brokerage account appreciates in value 5% a year. In that scenario, the estate tax savings would be $437,218. That $1 million GRAT would be discounted significantly because of your right to receive the income at 5% for 10 years. Now, the only negative here, a condition that you need to be aware of, is you have to outlive the term. So you have to outlive the 10-year period, or else the trust assets will come back into your estate. You won't be worse off, but you will not have realized that tax savings that I've outlined here at $437,000. So when my clients think about GRATs, they may do several GRATs, maybe for a 5-year term, a 10-year term, and a 15-year term to hedge their bets. So the discount will depend on how long the term is, how old you are, and what rate of interest you're paid. There is a minimum amount that you have to be paid under the federal law, and that right now is under 1%. So there's a lot of flexibility in the use of GRATs. Now, if we did a CUPERT, and let's say we had a residence worth $1 million, then and you retained an interest in that residence for 10 years, and you're at age 65, and let's say that residence appreciates 4% a year, the tax savings would be a whopping $362,892. So here again, significant savings can be reaped, and you're living in the house during the term. When you outlive the term, you can continue to live there. You will have a rental situation, but the tax savings are so significant. Let's talk about planning with LLCs and S Corps. Here, we want to convert ownership in a limited liability company or a subchapter S corporation to voting and non-voting interests, shares, or units. The non-voting interest will be discounted for lack of marketability and lack of control. So if someone owns a company and they say have voting and non-voting shares, would someone out in the marketplace pay the same amount for non-voting shares as they would for voting shares? And the answer is no, because if you have non-voting shares, you don't have any control over what happens with the company, and it's less marketable if you wanted to sell it. So there's a discount given, and that discount can range from 15 to 40%. That's a really great strategy, because if I'm gifting non-voting units, I'm still in control of my company, and I get this discount. I can even form a company and fund it with your brokerage account and get a 15 to 25% discount by gifting the non-voting units of the LLC or the non-voting shares of an S Corp that owns that brokerage account. And you could gift those interests to a trust for the benefit of your family, or make outright gifts to them. So here's an example of a discounted strategy approach. And let's say I had an estate of $23,160,000. Now, the same rules will apply regardless of the size of your estate. Right now, you'll see that total estate tax will be approximately $6,500,000. The federal estate tax at roughly 3 million, the New York tax at 3.1 million. It's going to get you up in the $6.5 million range. So let's say if we had an estate of that size and we were to gift 5 million, but I was able to discount it through one of the strategies I mentioned. So the discounted amount would be 3,250,000. So when that gift is made, the exemption I'm going to offset the gift with will be not 5 million, but 3,250,000. That would create a taxable estate of $5,355,440. But what's important here is to understand, well, what did I save my family? I saved them $1,180,000 due to the discount, plus future appreciation of the gift. So if I was to just make a dollar for dollar gift, I would only save about 480,000. By doing a discounted gift, I got it up to 1,180,000. Plus, very important, future appreciation. Money, there's the rule of 72. Assets double in value every 10 years with a 7.2% return. So you're saying, well, I'm not going to get 7.2, I'm going to get a lesser amount. So maybe it'll take 12 or 15 years to double your assets. Think about the size of your estate 10 years ago and what is it today. And you, in most cases, will see that it has appreciated in a significant way. Lastly, we'll talk about charitable gift giving. So charitable gift giving is a win-win situation. During your lifetime, you can make charitable gifts and you're helping a charity and you get a tax deduction. You might think about using your IRA or 401k account for that purpose, because that avoids you taking an income tax on that amount and then offset by a deduction. There are rules that come into play and limitations there, but it is a good strategy. You can do gifts in a way through the use of charitable trusts. And there are two types of charitable trusts: charitable remainder trusts and charitable lead trusts. A remainder trust is where you make a gift to a trust and you retain a right to an income stream during your lifetime. You get a tax deduction, which will offset your income tax and save you money right away, based on the value of the gift. The gift is the value of the asset put in the trust less the value of your income stream. The charity will benefit upon your demise by the assets passing to the charity. When you get your tax deduction on your income tax return, some of my clients will take the savings and buy a life insurance policy through an ILIT, sometimes referred to as a replacement trust. And now you're not only helping a charity, but you're replacing the gift you made to the charity with life insurance for your family. That could be a win-win-win situation. The other area would be charitable lead trust. This is the reverse, where you make a gift to a charitable trust and the charity gets the income interest, and then you control what happens with the remainder, the assets in the trust. Here again, you get a charitable deduction for funding that trust. Those assets are given away, but not really, because it's coming back to your family through the trust. You're really giving away the income interest. You can fund gifts with qualified retirement funds. I mentioned that, and that is also another strategy to be considered. So there are significant benefits of lifetime gifting through income tax savings and estate tax savings. So I really have moved fairly quickly through some of the strategies that are out there. There are others that we could talk about. The use of IDGITs, intentionally defective grantor trusts, and the use of skins, self-canceling installment notes. Every situation has to be looked at client by client, what your situation is, what's important to you, and how do you want to pass your legacy on to your family or loved ones. Now, we talked about tax reasons to do this, but there are also always non-tax reasons. Everyone wants to pass assets onto their family without problems and perhaps without probate, which will make it easier for the family and reduce some of the costs in estate administration. So that's another reason to have a comprehensive estate plan in place. Also, everyone wants to leave assets, I believe, in a protective way. So we've created the concept of family protection trust or safe trust, that you can leave assets in a way to protect your family while giving them access to those assets. If you have a loved one with special needs, we have created special needs trusts that can be utilized to maximize government benefits and protect those assets for your loved one. And also planning with long-term care, either through insurance or through the use of trusts as well. So you have an estate of X dollars today, but if you need long-term care in the future, your estate could be devastated by the cost of that expensive ongoing care if you needed it. So we always want to put a plan in place to make sure, either through trusts or insurance, that you're protected. It's always up to you to decide what you want to do. It's my job to let you know what the options are, what I think makes sense for you, share my experience and knowledge, and then you decide on the plan that makes sense. So the lessons learned here are that there are various strategies that are available to save estate taxes. You need to make a commitment of time, energy, and resources to implement such a plan. But think about how hard you work to have the assets you have. You're going to spend a lot less time, energy, and money in legal fees and other costs that may be related to putting in a well thought out estate tax plan. Most importantly, though, I say you need to be comfortable with your estate tax plan and make sure it meets your overarching objectives. Taxes should not be the only factor or even the primary factor in how you address implementing an estate plan for you. It's got to make sense. It's got to have your value system, how you think about passing a legacy on to family, what kind of protections you want to build in, who should be the beneficiaries, in what amounts, at what ages should they have outright control. These are all factors to consider, and you're the driver of this. You need to be comfortable with your estate plan. So with that, we're going to open it up to questions. And I see that a question came on early on from Michael. Michael asked, can you put a 529 plan for your grandchildren in a trust? And the answer is no, I do not believe you can have a 529 plan owned, that you can't put the funds in a 529 plan into a trust for your grandchildren. The other question Michael asked was, what happens if you want to do a CUPRIT, but there is a mortgage on the property? So that needs to be addressed in that you can put a residence in a CUPRIT that has a mortgage, and then you have to think about the consequences of that. It is a gift of a lesser amount because of the mortgage, so you may not get the same benefit you would if there was no mortgage on the property. And two, we have to look at the mortgage terms to make sure that this is a transfer that would not accelerate the principal being due under the mortgage. And so that's a consequence that needs to be considered as well. So you can do it, but there are certain limitations here that need to be addressed. All right, any other questions? I'm going to ask Ashley to come back.
No questions on Facebook.
Okay,
No.
so I know it's a lot of information. It does get very technical. You probably want to absorb what you've heard. You may want to then go back and look at these slide presentation when we post it. Um, and and if you do have questions coming out of this discussion, we are more than happy to talk with you, meet with you. Everybody's situation has to be addressed individually, and what makes sense and what thoughts we would have in terms of a strategy. All right, so let me just take a moment and just talk about our law firm. We have 4 office locations: Garden City, Lido Beach, Islandia in Suffolk County, Manhattan, Midtown Manhattan. So we're in convenient locations for you. We can meet in person. We can meet virtually by a video conference or even by telephone in light of what's going on with the pandemic. We've been around since 1985. All that does is make me old. But I'm the founder of the firm. We have handled thousands and thousands of family situations. In fact, over 17,000 families we've helped through the years in elder law, special needs, and estate planning. We also can be a resource to you in areas that maybe we don't practice in, but we've created a network of relationships with attorneys, financial advisors, insurance agents, care managers, locally and all over the country. I'm proud to say I have 5 partners. We have 4 associates. We have roughly 30 people in our office ready to help you. We believe in staying in touch with our clients in the community. We constantly are posting with our blogs. I do a daily check-in on Facebook. We have events ongoing all the time, like this webinar. You can go into our calendar on our website, or you can always call Ashley. Ashley's always available to you. Just call our phone number, ask for Ashley. And we're privileged that US News ranked us as one of the best law firms in the area of elder law. So with that, Ashley, anything you want to add before I kind of bring this to a close?
Yeah, as far as news and events, I did just want to mention briefly that we are participating in fundraising for this year's annual breast cancer walk, and we are a proud sponsor of the Alzheimer's Disease Resource Center Walk Your Way fundraiser. So to be sure,
We believe in community service, and so any help we can give, we do our best. And if you can also join us in helping charities, there are so many worthy charities locally and around the country. So if a charity rings true to you and is meaningful, jump in and help out. We all can use the help. So this last slide just kind of sums it up for me about tax planning. Those who plan and those who don't plan. And what we don't want to have happen is we don't want the IRS to get a bigger share of your assets because you didn't plan. It's almost the same analogy to having a will and don't having a will. And what happens when you don't have a will, you lose control over who inherits your assets. By planning, you control how those assets will pass. And you will maximize estate tax planning the most that you can pass and pass on the least to the IRS. Unless you really love the IRS. If you love the IRS, don't do any planning and they're happy to take your money. And so will New York State. So we're here to help you. Please call us for an appointment. Ask for Ashley. Our phone number is 516-683-1717. And if this presentation you think is meaningful to other family member or friend, please share the information or have them contact us, and we'll make sure they get this presentation. So everyone have a great day. I think I did Ashley's job there at the end, right?
You did. You took it from me, Vincent. I will say that I hope everyone stays safe during the holiday season. And with Thanksgiving, what, a week away, I hope everyone has a great Turkey Day.
All
That's all
right.
I got.
Okay. Well, that's a lot. Thanks, everybody.
Bye, guys.